The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday, the 27th of May, 2016, are currently trading with gold at $1,212.75 an ounce, silver $16.22 an ounce, Texas crude $49.48 a barrel, and Bitcoin is currently sitting at about 469 U.S. currency. Today in history, the year 1937, the Golden Gate Bridge in San Francisco is dedicated, in construction for over 4 years at the cost of more than $35 million at the time and spanning nearly 2 miles. The Golden Gate Bridge opening celebrations lasted for a week and began today in history. In recent news, a Greek archaeologist, Konstantinos Sismanides, believes he has discovered the tomb of the great philosopher Aristotle. Excavating the ruins of Stagira since 1990, the archaeologist told CNN that his team has strong evidence that the 2,400-year-old tomb belongs to the philosopher. The structure is about 40 miles east of Thessaloniki and is thought to have been built in honor of Aristotle's death in 322 BC. This place was named Aristotelion, and historical sources cite that locals would gather every year to celebrate the life of Aristotle. We know that Aristotle died in Chalcis, in the island of Euboea, Sismanides explained, but after some years, they took his ashes and placed them in a bronze vessel. They brought his ashes to his birthplace, the ancient city of Agora, and made an altar in a public building to celebrate Aristotle as a hero. Credited with radically transforming many fields of knowledge, particularly in physics, metaphysics, and logic, Aristotle remains a hero of philosophy to this very day. The SpaceX Falcon 9 rocket came down for a perfect landing at sea today during the successful launch of the Thaicom-8 communications satellite. With a flight time of less than 9 minutes from liftoff until touchdown, this landing marks the third drone ship landing at sea for Elon Musk's SpaceX Falcon 9 rocket. This Memorial Day weekend, we not only call remembrance to the nearly 4,000 U.S. military combat deaths in Iraq alone, but the roughly 12,000 suicide attempts by American personnel a year, half of which or more are being successful, and the terrifying estimates of 1.5 million civilian casualties in Iraq since the commencement of Operation Iraqi Freedom in March of 2003. This is Rick Rohde with your lowdown for May 27, 2016.
Received my remedy today. Came in a box, just like they say. I accepted it for value right away. If not sooner, not later.
Hi, we are back with Rule of Law Radio, Randy Kelton, Vet Pack, and it looks like we've got Oliver on the line from Tennessee. Oliver, what's going on with you?
How you doing? Hello? Hello?
Go ahead, Oliver.
How you doing, man? I called you last week about the house that got tore down by the city, and you were telling me to go look at their code, the codes that they charged me with and everything. And I went to look at it, and they charged me basically with a city code and a Tennessee code as indicated, and it says removal of vegetation and debris from certain lots. And I've been listening to Eddie, and rabbit trails and defining the words to figure out what the actual code is talking about. When I figured it out, it's talking about rental estates, rental people, corporations, housing corporations, and commercial enterprises. So I'm like, So I found this out, and I went to the code department. And I showed them. And another one was title and scope. It was title and scope of some code, and it didn't even give a proper. It was just title and scope. It was just definitions and what the chapter was about. So I brought this information to them, and I was like, well, I had an attorney tell me to go look over your code, and I didn't understand why. But now I see why. I was like, well, you charged me as a housing enterprise or a commercial enterprise. And I showed them their code, I explained it to them, I walked them through it. And I explained that they didn't have the right to do what they did, even with the codes that they had. Then I showed them all the laws all the cases that I found from Tennessee, and where it states that regulatory taking is protected just as the taking clause of the Fifth Amendment. And so once we got through the conversation, we talked back and forth. Before I left the office, I believe I heard an offer. Like I didn't go there trying to get an offer or demand an offer. I just went there because I was so interested about what I found out about the code that they charged me, and I went to show them. I just wanted to show them, like, what are y'all doing? And once they saw all the evidence, they were like, well, we can send this to our legal team because we don't really know how to answer you or anything. But then he was starting to talk about $5,000 for the. He could see that I'm in need of finances or something. He said, how about if the same city that taken your property was able to help you obtain it back? I was like, huh? And he started talking about numbers. I was like, well, I didn't get that far. I'm still breaking down the laws and seeing how they apply to see how we got to this point in the first place. So money, I haven't got that far yet. I need to go home and think about it. I told them I would entertain any offer that they sent to me because you got my number in the case file and everything, but I wasn't prepared to talk about money or anything like that.
So apparently they recognized that they may have overstepped their bounds.
Right.
But I have a question. Why did you give them fair warning?
They already knocked the house down. Oh, well, we had a little, I'm a people person. Once I went and read their code, we had the, friction. Once I went and read their code, I guess, got sentimental to see that, they were manipulated. They are manipulated to do what they're doing. They even admitted it after I showed it to them. They're like, whoa. And I was also going to the city hall.
Okay, wait a minute. You know what they did as soon as you walked out? They went to their lawyer to figure out a way to get around what you brought up.
Oh, I understand, but it's too complicated.
Well, it goes to never give fair warning.
Gotcha. Okay.
Don't give them an opportunity to find a way to screw you. If there's any way you can avoid it. I used to think that you could go to these people and reason with them and they would act in good faith. They will do no such thing. They will do everything they can to cover up their screw-ups and anything they can to screw you out of any settlement.
Mm-hmm.
So try to avoid giving them a heads up. Bushwhack's a whole lot more fun.
Yeah, bushwhack.
You don't get the opportunity to force them to explain themselves to you. You have to forego that. But it's a whole lot more fun when you force them into a position where they have to explain to a court rather than you.
Okay.
And if I were going to go talk to them, I would only be talking to them for the purpose of getting them to screw something else up.
So,
you've heard my tar baby analogy.
No accepting any offers.
Yeah, I've got this little tar baby, and I take it, and it's invisible. You can't see it. But I got it in my hand, and I go to this public official, and I say, here, I got this little tar baby. You want to touch it? Here, go ahead, touch it, because they're going to stick to it. The only time I go to public officials is to ask them to do something they're not going to want to do.
Huh?
And then get them to not do it. So then I can hold them responsible for not doing it. Here, if they have knocked down your building without proper authority, that's more than civil. That's criminal. They stole your property. That would certainly be the first place I would want to go.
So, grand jury?
Say that again. I missed that.
5 charges. I mean, you would be going to 5 charges with grand jury?
I couldn't understand that. I'm having a little trouble.
I said,
Yvette, could you understand what he's saying?
Something about grand jury.
Yeah.
Oh, no, not yet. Well, yeah, grand jury would be a good place. Yeah, grand jury would be an excellent place. Because grand jury are your peers. They're not public officials. They're in an official capacity, but they're ordinary people. Take complaints against these guys to the grand jury, and that's why I say I don't like to give them fair warning. Because when you go file against them with the grand jury, they don't really know why you're filing, unless, and investigator comes and starts asking them questions. And now when they're talking to the investigator, they can't afford to screw around very much because they might be able to pull the wool over your eyes, but they're not going to do that to an investigator. So you may well get them to screw up even more. But certainly criminals best to do first, because then you get the criminal investigators to do a lot of your homework for you.
Again, too. Sorry?
Wait, say that again. I'm having a little trouble understanding you.
Against who?
Randy, he said against who?
Oh, against whoever, against the mayor. The mayor is responding at superior. Everybody in the municipality works for the mayor. And they do what the mayor tells them. What they do in the name of the mayor. So you sue the mayor. Or file against the mayor. And the mayor is going to have a conniption. Because he didn't have anything to do with it. And the only way the mayor is going to get out from under is to throw one of his people under the bus. I didn't do that. This guy over here that works for me did that.
Okay.
And he's going to... So you get the mayor in a position to where he has to throw his own people under the bus to keep from getting run over himself. Create you lots of politics.
But the code department, when I was talking to them, I was showing them how it reads and how how they orchestrated the deception. They was throwing everybody else they threw everybody else underneath the bus. They were like, look, we don't know the law like you're explaining to us. They tell us what to do. We get pressure every day to go to your house or do something about it. They said that wasn't us. I'm really sorry this happened. But somebody from up top is pushing pressure on us. We don't come here. We don't come to work to go, mess with you, Mr. Olivier. We're going to take the information and we'll bring it up there. But just like you said, we are getting pressure from up top, and we just find
good, perfect. If you can get the guys at the bottom turning on the guys at the top, if you get these guys turning on each other, wonderful. They'll work in your favor. I had a real important point. I just lost it.
I'm trying to figure
it gets worse as I get older. Okay, yeah.
I'm trying to figure out, how do I set a value on? Is there an equation on, setting a value on what you lost, how much violations? I got several trespassing because I have almost a dictionary full of pictures of different days they came on my property.
Okay, there's a lot of pro se's have a lot of problems with this. You need to find a case where someone there has sued them for improper taking and see how they calculated their claim.
I have a case. I have a case that I can't find how to figure out how they got compensated or how they calculated.
What did they claim in their petition? How did they make their claim for damages?
They claimed for regulatory taking.
Okay. If you have a court case, you probably have the order from the judge. You might want to go in and look up the actual pleadings that were filed and get the original petition. The original petition will demonstrate how they calculated their damages. Hang on. We're about to go to break in about 30 seconds. Vet, you want to take us out?
Yes.
Original.
This is Rule of Law Radio. Randy Kelton, Vet Pat. Please call us at 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let not-mind people hurt you. Until Satan get behind you. Know what I mean? My friend. And all of your children. Come on. Those things that hurt me free. Tell him your problem name. Call on his name once again.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Okay. Oliver, go right ahead.
Okay. I think Randall was telling me about the original petition and certain charges against the mayor.
I'm still having trouble with it.
Can you hear me?
Try moving the mic a little further away from your mouth.
Further
And
away?
I think you're talking faster than I can listen.
Okay. Can you hear me now?
I can hear you.
Okay, you were talking about pressing charges on the judge. And
Yes.
the original petitions on cases on cases of taking and regulatory taking. Look at the original petition.
When you look up
that was,
court cases, you generally find the ruling of the court, and they don't always show you everything. If this is a federal case, then you can go on to Pacer. Do you have a Pacer account?
yes.
Okay, then go on to Pacer and look up the pleadings. You want to see the original pleadings. And if there are any briefs filed, you definitely want to see the briefs. It's my position that if you're writing a legal document and you're doing more than transitions, changing the he's to she's, if you're doing more than stitching pieces of case law together so that it all reads well, then you haven't done enough homework. You should never write these pleadings. You got all of these orders by judges. They write stuff a lot better than we can. So get these lawyers' briefs and plagiarize their briefs. So if you're not plagiarizing other people's stuff to build your motions, you need to do more research. So go in and find the original pleadings. And in that, they'll tell you how they calculated. For false imprisonment, we have a case, Travasant out of Florida, where he got like $21,000 a minute. He was held for, I forget, an hour or two, and he got $70-something thousand. And whatever it was, it calculated out $20-something thousand a minute. So they say, okay, I was held this long. A jury awarded this much a minute, so I calculate this amount of time by this many minutes, and you come up with a number to the penny. So when the other guy says, like, you claimed $10 billion, how did you get that? I actually had two guys call me out of North Carolina. They filed a lien against a judge for $11 trillion. I said, well, what was the case? Traffic. What were you thinking? How did you get that number? Oh, well, we just made it up. I said, well, the U.S. attorney's going to make it up when they stick you in jail. When you claim a number, you need to be able to show them a calculation. It don't matter if that calculation is horse manure. Just so you got one. And you can say, this is how I calculated this. And they can say, oh, well, that's wrong. You can't calculate it that way. And blah, blah, blah. The only thing the jury's going to remember is the number you walked in the door with. The other side can argue about how you calculated it. But if you just picked a number out of the air, that's really easy for them to blow away. So find some calculations in the pleading and use their calculations and make your own, like fair market value of the property, estimated amount that it would take to bring your property up to fair market value. How long have you had the house and how attached to it are you? Throw in a little extreme emotional distress because are you a veteran?
My wife is.
You say your wife is?
Yeah.
Okay, great. The price she paid for these rights and they stole them? Man, these guys steal one of my rights. And I'm real quick to tell them, maybe you don't take your rights real serious. But I do.
They took about, it took, I think, close to 10 cars, right? About 8 to 10 cars off my property.
And I cannot understand you. You need to move the mic a little further away from your mouth.
Can you hear me now?
Yeah, that's better.
They took about 8 to 10 cars off my property.
Yeah, and you were emotionally attached to those cars. Did you have any that can be construed as antiques?
Yeah, 67 Mustang.
You're getting the mic back against your mouth and you're distorting real bad.
Mustang.
I heard him, 67 Mustang. I would have had that car.
Yes.
Continue. Go ahead.
This gives you some things that you can do some real calculations on. And don't matter what the number is, just so that you can show you did some calculations.
Okay.
But first, walk them through the criminal side. Taking them through the criminal side, you'll develop information you can then use for civil action later. And they'll come back and claim double jeopardy. No, it's not double jeopardy. Criminal punishment is separate from civil litigation. They'll want to claim that you can either do one or the other, and that's horse manure. You don't prosecute criminally, so you don't have anything to do with that. You have a duty to give notice of crime. It's the prosecutor and the state's duty to enforce it, so you don't have anything to do with that. You have harm separate, so you can do both. And I suggest do the criminal first. Use the criminal to develop your civil side.
Use criminal to develop the civil.
Yeah, concentrate on the criminal now, but look at it from the perspective of you want them to bring in information as a defense that you can then use to sue them with. When you're trying to keep out of jail, they're not going to be so worried about being sued. And they're more likely to give you something you can use. Okay, now that morning, the cops were out there. They said that the cops told me that they was out there for security. Now, when I tell everybody the story, they're telling me that it was a setup. They said that the cops were out there for security. They tell me they were not. Okay.
Okay. Well,
if the city did not have authority to take, then the cops were out there using their guns to steal your property. Now, I'm sure they didn't think about it that way, but sorry, Bubba. When the bailiff put his hand on my arm, when the judge had told him to arrest me, and he walked up and put his hand on my arm, he was prominently displaying a deadly weapon. Now, I'm sure he wasn't thinking about using that weapon, but I was thinking about him using that weapon. And when he put his hand on my arm, the code says first-degree felony aggravated assault, 20 to life. Okay. Helps. Sometimes you raise the stakes for them. You know, if they come after you criminally, they're going to charge you with the most outrageous thing they can find so that they can negotiate back to something they can get a lot of money from you with. So do the same thing. I'll go in and sue this judge for subjecting me to first-degree felony aggravated assault. And he's going to jump up and down, oh, I didn't get it, they didn't indict me for it. Well, tough. You see where I'm going here?
All right, but if I file, I thought your concept was not to get them indicted. If I filed and they press charges on the mayor, then what?
Okay, well, see, you don't have anything to do with whether they get indicted or not. That's the prosecutor's job. Your duty is to give notice. And the reason, I tend to say, it's not my purpose to get an indictment, because if I don't get an indictment and that was my purpose, I've lost. If it's my purpose to kick their behinds, then I win either way. Hang on, about to go to break. This is Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number, 512-646-1984. We've got another hour, so give us a call. We'll be right back.
Please scan your next item. That annoying mechanical voice from the self-checkout lane may soon be silenced for good. I'm Dr. Catherine Albrecht, and I'll have great news on the death of computerized cashiers next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Apparently, I'm not the only one who hates the self-serve check stands at stores. After a decade of trying them, retailers are finally acknowledging studies that say shoppers would rather dodge the self-serve lane and head for a human cashier. Today, just 16% of grocery store transactions go through self-checkout lanes. That's down from a high of 22% 3 years ago. Shoppers say they're more satisfied when they pay people, not cold computers. In response, grocery chains like Big Y and Albertsons plan to bag the do-it-yourself option and bring back customer service. Hooray! Now, if only they dump the purchase tracking membership cards. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Vet Pack, Rule of Law Radio, and we're talking to Oliver in Tennessee. I think I asked you once before, do you play chess? Oliver.
Yeah.
Good. This is a chess game. And criminal accusations are pawn moves. We're setting up, before you file a civil action, you want to get it set up. You might think of the kinds of information you're going to want when you file a civil action. And then go in and start crafting information requests. You want to do all the information requests that you can before you file suit. Once you file a suit, generally your public information laws are bypassed because they don't want public information to supplant discovery. So you do all that public information stuff first. Then they don't get to go to the judge and ask the judge to deny it. So collect all the information you can, so when you file your civil action, you've already got them set up. And when you, like you were saying, these guys are already throwing one another under the bus. So you go after them criminally, and they come into court and say, on the stand, under oath, this wasn't my fault. I acted in good faith reliance on competent authority, and that guy over there was the competent authority. Now you have court testimony establishing that this guy over here is the tortfeasor.
Can I interrupt you for a second? They had me come to a meeting, and I recorded that meeting between the codes director and the city attorney. And I told them, and
I was going to ask you if you had recorded those. Good for you.
Yeah, I told them that it was private property and everything that they was dealing with. And they told me that, no, I'm misreading the law. The state gives them the right to do this and that and that. That's the process that they're taking. I'm like, the state gives you the right to do this? And they're like, yes, I'm 100% sure. He said, I don't know what I'm talking about. And I have them on record, on recording, saying who gives them authority to do that. And this is the city attorney.
Wonderful. The city attorney's giving you legal advice?
He's telling me to go get attorney, and the attorney will explain to me because I don't understand law, and the state gives them the authority to do what they're doing under state law.
And you say, okay, where specifically did they give you that authority? But generally, you need to do this research. You might want to go talk to a lawyer, not hire him, but talk to a lawyer on eminent domain issues. Maybe pay him $50 and get his input.
On eminent domain issues.
Eminent domain. That's how they take the property. They have to go in order to do the condemnation proceedings. They have to do it under eminent domain. They have a special. I can't condemn your property because I don't have that power, but the municipality does under eminent domain.
Does that go through some type of court?
You're breaking up again.
Isn't that supposed to go through some type of court?
No. They have it's not a tort unless they breached their right to eminent domain. They're going to claim authority to do this under eminent domain. You need to study eminent domain in Tennessee to see how it applies to your situation.
Right. Eminent domain consists of a court procedure. I read it. I'm familiar with it. That's why.
Okay.
I read the case laws, and it includes a court procedure. I went to all the courts and tried to get documents. No courts have it. I went back to the codes department and asked them themselves, and they told me no, they don't go through any court procedures. I'm like, well,
so they're they're claiming statutory authority then.
Yes.
Okay. Now is it Tennessee state law they're claiming, or is it municipal ordinances?
State law and ordinance.
Okay, then you have to research out those codes. But if they have failed to follow it, when they start taking
one is a state code, and when you read the state code, it breaks down to housing enterprises and corporations. Commercial.
Okay, and that makes sense. That fits. because the municipality is a corporation.
Right.
And
I understand that.
Other companies doing business within the venue of the municipality has to contract with the municipality in order to do that.
Right. That's why I asked them, do they have a contract with me? They looked at me like I was crazy. They said I lived in the city. I'm like, oh my God.
Okay, where is that in code? Whenever they make that up, whenever they say something like that, okay, show me that in law.
But I mean, my intent was not to hammer them, because I kind of, the way the situation went, I'm kind of realizing that somebody got their foot on their neck. You know what I'm saying? And like, that's why when you told me to read the code and I read it and I seen how everything play out, I'm like, if these people actually read it and took some time to, because I made so much protest against it, if you had to sit down and read it, you would have actually said, okay, I understand what's going on. So somebody's pushing you to do this. When I showed it to them, they were like, well, you know what? I have a job to do, and I come in, I take orders, and I follow through my orders, Mr. Olivier. I'm understanding you now.
Okay, that may work in your favor.
Right.
If these people on the bottom are afraid that you're going to come after them, what they're likely to do is feed you the guys who gave them the orders. You watch these cop programs where they're going after drug dealers. Mm-hmm. They get the user to tell them who their supplier was, and then they get the dealer, and they work their way up the chain.
I was going after criminal charges against the code department, the code director, and the city attorney. But after I had that conversation with him, like, I felt so bad, because like I didn't know him. Like, after the conversation, I got to know him. Like, man, I'm happy I got to know him before I actually went through pressing the charges, because now that the situation is explained out all on the table, I see that I'm going after the wrong person. They have to come to.
Well, maybe the one who actually committed the act. That's the place you have to go first.
And that's basically she's signing off on everything.
Yeah, see, all you know is if somebody came onto your property and destroyed your property, you want the person who did the destruction. You get him, and you put the pressure on him, and get his work order, get copies of the work orders he used in order to come and do this. So now you got the one who, he gets off the hook, and if you tell him you have to come after him, but he needs to give you evidence of competent authority.
All that is being provided. They provided me all the pictures and everything that was going on through there. That's how I realized there was no court procedure, because I went through all the documents. I'm like, wait a minute, I don't see no court documents. Let me go to the courts and make sure. So they give me everything, but I'm missing the what gave.
Okay, so you already know where you need to go at this point.
Yeah, they got that paperwork come to me. I'm getting it Monday. They already have it prepared for me to receive.
Okay, then we're probably as far as I can go here. Hang on, about to go to break. Randy Kelton, Vet Pack, Wheelville Radio. Our call-in number, 512-646-1984. Charles, I'll see you there. We'll get to you in this next segment. We'll be right back.
This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, and we're about to bring on Charles, I believe. Randy, you want to bring him on?
Yeah, we just finished up with Charles. Charles, I guess we've kind of went as far as we can go with this. Do you have anything else that you want to address? Hello, Charles. Are you there?
This is Charles in Georgia.
Oh, Charles in Georgia. I'm brain dead. Well, I was thinking of Oliver in Tennessee. He dropped. Oh, wait. Oliver dropped off and called back in. Charles, give me just a second. Let me make sure I'm finished with Oliver, and then I'll come right back to you.
No problem.
Thanks for being patient. Okay, Oliver, I see you must have dropped off.
Mm-hmm.
Okay, do we have anything else, Oliver?
What's your advice on that? I mean, I got the paperwork coming, so when the paperwork comes, trace that paperwork down and see who authorized it. And that's who I go after criminally. Is that what you're telling me?
Okay, is that a question? I'm not sure.
Yeah.
Okay, you've got the paperwork showing who authorized the destruction.
No, it's on the way. It's being copied.
Oh, okay. Okay, when you got that, then you go after that person. And if somebody else ordered him to do it, he will. You see, if you acted with good faith reliance on competent authority, that's an affirmative defense. So in order for this guy to get out from under the claim of theft of your property, he's going to have to show that he had competent authority. And he'll throw somebody else under the bus for you. And that can get to be great fun. Okay. Keep us up to date. We do need to move along. Charles has been waiting a long time.
All right. Thank you.
Okay. Thank you, Oliver. Okay, now we're going to go to Charles in Georgia. Hello, Charles.
Hey, everybody.
What do you have for us today?
Okay, I have a question. Regarding.
Okay, hold on, Charles. Your mic is distorting really bad. Can you move it down by your chin a little bit?
Is this any better for you?
It's a little better. It's still kind of booming. Are you on a cell phone?
Yes. This would be
can you turn your volume down a little bit?
All right, let's see.
Okay, go ahead. Give me a mic check.
1, 2. Check 1, 2.
Oh, muy better. Muy better.
2. Okay. I did actually have you on extra volume. I'm sorry about that. I needed to hear you. I had a question about Oliver. You mentioned Travis Atta in Florida and his $22,000 a minute
Travasant.
lawsuit.
Look up Travasant. It's a real famous case. Everybody in legal reform quotes Travasant.
Okay,
Randy, what is Travasant?
Wait, say that again, Vet.
What is Travasant talking about?
It's a guy who was I think he was pulled over in a traffic incident, and he was held for a couple of hours, and then they released him. And then he sued him for false imprisonment. And whatever he received amounted to, I think, $21,000 a minute. And that's what the jury awarded him. So now we can say the jury, by awarding him this amount, set this precedent. This is what our time is worth according to a jury. So we take the time we were held and multiply it by this factor, and we get this amount of money. And we can calculate that to the penny.
Okay.
So when the other side comes in and says, well, how did you come up with this number? We say, well, this is how we come up with the number. And they're going to say, well, that's not valid. Okay. Show me a valid number then. Looks valid to me. And the whole thing is, once you file a case, the other side's going to argue and try to bring down the amount of your claim. But at the end of the day, the only thing the jury's going to remember is what you walked in the door with. So long as you can show some rational, reasonable way that you come to that.
Okay.
And
Charles, I don't have the citation for Travasant. If you'll send me an email, I'll look it up and I can get it to you.
Okay, no problem. I'll do that.
Okay, move the mic down by your chin. You're still booming really bad.
Okay, is this any better?
Oh, much better.
Okay. I got in touch with a Title 42 lawyer here in Georgia. I'm not going to say his name or anything. I asked him if he could help me, or would he like to take my case? And he asked me a couple of questions that I wanted to ask you about. He asked me, when did the traffic stop happen? And I told him it happened on January 20th. And he asked me, where am I in the case? And I told him that I haven't even pled yet. I haven't pled
Wait a minute. Your mic is still distorting really bad. Move it a little farther away from your mouth.
Okay. And I told him I haven't given a plea yet. And so his response was, to me trying to file a 42, here in Georgia, I guess the statutes say that I have 6 months from the time that the incident happened to give the court notice that I would like to sue them civilly in order to make a claim. Now, this 6 months is coming up June the 20th. My question to you is, since this is still ongoing adjudication.
No, wait a minute. Something's wrong here. You're talking about a 42 U.S. Code 1983 suit. That's federal.
Yes.
There is nothing the state can file that abridges your federal rights, period.
Okay. Because according to this 42 lawyer, and he wrote me back, I haven't spoken to him, but he wrote me back, and he said that there's a 6-month period, and it depends on what happens in the in the case here locally about what I can do with my 42.
Okay. No, the state can't have anything to say about what you can do in a 42. The whole point of a 1983 suit is about suing the state for acting improperly. And the state doesn't. This is a federal issue. The state doesn't have anything to say about it.
Well, that's the impression I have. I was under the impression that it doesn't matter, even if I lose here, my traffic ticket case. That doesn't matter because they still didn't take me before a magistrate and they still acted wrongly. So I didn't think it actually mattered. But according to him,
no, so long as your case is in litigation, the clock hasn't started running yet.
Okay.
There's a case out of Chicago where a judge was incredibly corrupt. And for Chicago, that's pretty common. He was on the bench for 19 years. The feds finally went after him. And they said as long as he was on the bench, the clock on his issues never started running. Because he's in a position to circumvent any action against him using his corrupt position. So the clock never started running. Here, where you're being prosecuted, the harm isn't completed until the prosecution has finished what it's doing. Because they're still in process of harming you. That's like saying, this guy shot me 6 times. He shot me once a month for 6 months. And they're going to say, you can only sue him, your statute of limitations starts the first time he shot you. No, it don't. It starts the last time he shot me.
Yeah.
So as long as you're in court, they're still producing harm against you. So the clock hasn't started yet.
Okay.
And a lot of times lawyers just simply don't know what they're talking about.
And that's unfortunate because I asked him this and he sent this to me yesterday, and I haven't responded to him because this was a head scratcher to me because it didn't seem feasible to have an ongoing but adjudication going here, and that the clock has started and nothing has been adjudicated.
Right. Yeah, that doesn't make sense. For a Title 42. Okay, there may be something in there that does make sense, and we just don't have all the information. Maybe there's something he's considering that he hasn't articulated well, so you don't understand where he's making his claim from. It would probably make more sense if you could talk to the lawyer directly and sort out why he made this claim. But as long as you're in adjudication, they can't start the clock because they're still committing harms against you. And the whole point of RICO is ongoing predicate acts in furtherance of an ongoing criminal conspiracy. The whole point is ongoing.
Yeah. Well, I will send
wait a minute, hold on. We're about out of time here. Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story. I will occupy my father's house until he returns.
You're listening to Rule of Law Radio. This is Randy Kelton, Vet Pack. And we're talking to Charles out of Georgia. Charles, what else did you want to ask Randy? Was there anything else?
It was. And I would like to recount what happened to me. I was arrested, accosted, and imprisoned on January 20th by the Smyrna Police Department, Officer Hill, for making an improper left turn and not having a Georgia driver's license. I do have a valid Michigan driver's license, which Michigan is my domicile, which Michigan is my home, and Michigan is my residence. I am here in Georgia temporarily. And that's what this case is about. The arrest, and I've been listening to Eddie Craig, and I'm going to use Eddie Craig's strategy and courtroom strategy and procedure. Now, I've been listening to you, and I would like to, I'm going to do this as a pro se as far as here in the local courts in the municipality. And Eddie has a set of questions or interrogatories that on his blog site that I'm going to use in court. I'm going to need some more questions and things to come up with to question this officer about what happened on that night. Where can I look, and what do I need?
I have no idea. I don't understand. I don't know enough about what occurred. Off the top of my head, I'm going to say, before you go to merits, I'm always reluctant when someone goes to merits. When you ask the officer about what happened that night, the first thing I would want to ask is, what happened that gave you reason to believe that I fell within the regulatory scheme of your authority? You understand where I'm going?
Yeah.
Okay, Georgia Transportation Code is a commercial code just like most every other place. What evidence did he have to believe that you were in commerce so that you fell within the regulatory scheme?
Okay.
That's the first thing I want to know. I never see that in the citation. They never establish those elements. But in order to prosecute you for any crime, they have to prove up every element of the crime, and one of the primary elements is jurisdiction. Have you looked at the Georgia Code to determine who can enforce the traffic code?
Randy, I've been looking for that high and low. It's so vague. I've been looking for, okay, is it a police officer? Is it a peace officer? Is it just the state patrol, the highway patrol? Is it the local municipalities? Is it the chief? Is it the sheriff? I can't find it anywhere in this Georgia Code who is exactly authorized, certified to come in and enforce the motor vehicle code here, Title 40.
Are motor vehicle violations construed as criminal acts?
Class C misdemeanors, and here Class C misdemeanors are civil infractions.
In Texas we have an administrative code that addresses who can enforce, and we have the transportation code itself addresses who can enforce. Did you read through the transportation code? It's going to be in the front.
I read all of the transportation code is Title 40 here. Everything in Title 40 addresses, it just says any police officer. A police officer is a peace officer, so that it's not like in Texas where you have a constable, a police officer, or a peace officer. Here in Georgia, they have police officers and peace officers, but they are now one and the same. Peace officers are now police officers.
Okay, I understand. So you don't have that separate distinction. So, and then you probably don't have these issues we raise about who is authorized to be certified to enforce. So all officers are authorized to enforce the transportation code. Okay.
Randy, can you just pull up the transportation code on the internet? Where are you guys finding this information?
Look, you would, if it depends on the state, you just look up like Georgia Transportation Code. I'm sure you'll find it.
Okay.
If you can go to OCGA 40-1-1, that's the beginning of that's the beginning of the motor vehicle code here in Georgia.
Okay.
Yeah, Texas is somewhat different than most states. Most states have their statutes arranged in the form of general statutes. And they number different sections. Like in Pennsylvania, Section 12 is in 12 and 14. 12 is their criminal procedure code, and 14 is their penal code, if I remember right. But all of these codes are just one after the other. Texas is somewhat different. They put them in whole different books, but most of them are like Georgia. All of the codes are in one set of codes, and they just number them consecutively.
And when you go to find those codes, you just go online and just search Texas code, or you have to go to a records?
Right. When I do legal research, I use Google.
Oh, okay.
I used to use Westlaw. I used to use Lexis, but I find I get better results just with your standard search engines. It's all about how you ask the question. If I want to find the transportation code for windblown Egypt, I'll put in transportation code, windblown Egypt, start going through what I find. Okay. If I have a legal issue, I put in as best I can describe it, and in no time I find what I'm looking for. When I use Lexis, I put in an issue and I get 1,000 cases, and most of them are nowhere near on point.
Okay.
When I do it on the internet, it's a lot easier than you think. It's really straightforward. So if I could multitask, I could do this while I'm talking. But I'm old and I can't. No, it's really not hard to find law at all. And most people who listen to this, it sounds like what we're doing is so involved and complex. And that's really not the case. When we go after an issue, like if we're pro se, lawyers, they have to know all of the law. We don't. We have to understand basically how the law works, and then we have to have the law that goes to our issue. So we don't need all that masses of information that a lawyer has to have in his head. We only need the information that goes to our issue, and it's a lot easier to find than you would think. I had someone call me for weeks and weeks wanting to know if you could tape record someone in Florida without their knowledge, so long as you were a part of the conversation. And I kept telling her how to look it up, and she never did. And finally, one day she called in, and while she was asking the question, I typed in recording Florida, and boom, 10 seconds I had it. It dropped me right on top of the citation. It was really easy to find. The world that I grew up in is nothing like this one. Information is right at your fingertips. If you just think reasonably about how to find it, it's not terribly hard at all.
Okay.
Okay, I'm going to get off. I'm ranting. I think I'm ranting. but thank you, Vat.
I'm going to tell you that here in Georgia, Title 16 is the criminal code here.
Title 16, okay.
Giveaway. Title 40 is the motor vehicle code. So that's the dead giveaway that anything that is not in 16, everything in 16 is criminal, and everything that's in 42 cannot be criminal at all. Otherwise, it would be in Title 16.
No, that's not necessarily true. That's specious logic. Logic based on false premise. There can be two sets of code that are criminal, and just because one of them has a name criminal code doesn't necessarily exclude anything else from being criminal.
Okay.
There has to be an enacting clause, something in the code that states to whom this applies and who can enforce it. It may not be in Title 40. There may be a section somewhere else that says these certain codes fall under this enforcement strategy. See what I'm getting at? Probably look in the front of the criminal code and see what the enacting clause says.
Okay.
Somebody can't enforce something unless the law specifically says they can do it. Because the police officer can't enforce the Clean Air Act because he has not been specifically empowered to do so. Public official may only do what he is specifically authorized to do. So, If you can't find anything that specifically authorizes a peace officer to enforce the traffic code, that might be a question you want to bring. You claim that they can't enforce the traffic code because nothing in there says they can. And then if there is something, they'll come up with it.
Okay.
I sent an information request to my chief of police when I got a ticket here in Decatur, Texas. And I'm sure Vet knows Rex Hoskins. He's the chief of police.
Yeah.
He's somewhat portly gentleman. Mm-hmm. And I get along with him real well. But I ask him that question. Where do you get authority to enforce the code? And, well, actually, I asked him for his specific authority, and he responded back that they didn't have it, and they do not enforce the commercial traffic code. Gotcha, guys. They may just be doing this because they've always done it. Okay, hang on. Be right back. Don't want to fall off a cliff.
This is the Logos Radio Network.
Oh, come on. If I can't get everything I want.
This is Rule of Law Radio. You're listening to Randy Kelton and Vet Pack. We're speaking with Charles. Charles, go ahead. Did you have another question? Are you there?
Yes, I am.
Did we lose you?
Nope, you didn't lose me. I'm definitely here.
Okay.
If you can hear me. Yeah, I can't find anything in Title 40 that actually gives them any authority. But I guess Randy said it wouldn't necessarily be in Title 40. It could be somewhere else in some other section somewhere else. So now I have a question. How the hell how do you know what you're looking? How do you know what you're looking for, but you don't know where to look?
That's sometimes a problem. You might go down to the courthouse and see if you can talk to a prosecutor. Tell them you're doing some research. Tell them you're homeschooling your kids. And one of your kids came home from high school and had this question: where does the police get the authority to enforce the penal code and the traffic code? You know, feed them a line.
That's clever.
See if you can get them to tell you. You know, if you don't treat the prosecutor like an enemy, you know, they're generally pretty cordial and helpful. And don't tell him that you're researching it so you can kick his behind. But if you feed him a story. I do stories sometimes when I'm talking to public officials. A public official, I assume that if a public official's lips are moving, he's lying. So it's okay for me to tell a little white lie on occasion. It's just a minor fib, just to bypass all of this tension stuff. Mm-hmm. My daughter wants to be a cop, and she was studying it, and she don't know how they get authority to enforce anything. Yeah, they'll tell you everything.
Okay. All right. Well,
does that answer your question, Charles, or are you still questionable?
No. I know what they're going to, because I've had this come up before. I asked not a probation officer. What do you call the people who take your children away from you?
Child Protection Services. CPS.
I came across a lady. Yes. I came across a lady, and she was at a gas station. And I asked her, I said, what gives you authority to do what it is that you're doing? And her thing was, it comes from the Georgia Constitution. I looked at her. I said, can you show me in the Georgia Constitution where it says that you can go into somebody else's house, regardless of what they're doing, and take their children away from them? She said, it's part of the criminal code and criminal act. I said, no, the police officers enforce criminal codes and procedures. I'm asking you, what gives you the authority to take children away from people's homes? Not being facetious, not being argumentative. I just want to know where does a state that you know the story?
Try this one. I have a friend who worked for Child Protective Services, and she was trying to get these two little kids away from their parents who were drug addicts. And she couldn't get it done, and it was in the winter, and the 2-year-old got out on the porch. The 3-year-old went to get her back in. The door closed behind them. They both froze to death on the porch. And it just killed her soul. So how would you, if you're in Child Protective Services, what authority do you have to intervene here? What law gives you a way to go in and do something to help these kids? That'll get you a lot better answer. But that is a true story. People pick on Child Protective Services. Say, man, you need to go talk to these people. I could not do that job. It would rip my heart out. So, we pick on Child Protective Services, but for the most part, we don't see the bad side, the hard side.
No.
But you ask them that way, and she tried to do it and she couldn't get it done. What should she have done that she didn't? What laws or what statutes give her authority to do this? And they'll tear the statutes apart for you.
Okay. That sounds good. Okay,
be creative. We don't call it fibbing. It's being creative or artfully vague. Okay, thank you, George. Charles, keep us up to date on how this goes.
Thank you, Randy. Take care.
Okay, Vet, it's all yours.
Okay, well, we've got enough time to bring Ralph on, don't we, out of Texas?
Oh, yeah, we got another 4 minutes, yeah.
Okay, let's go ahead and bring him on and see what's going on.
Hello, howdy. Have a good evening.
Hi, Ralph. Good evening to you. What's going on?
Thank you. Well, I have some thoughts on what Charles was talking about with the notice in Title 42.
Okay.
And I don't know if this is right or not. This is the way I understand it, okay? In Title 42s, you can sue people either officially or individually. If you sue them officially, you have to give notice to their employer within a certain amount of time. Usually that notice is 6 months. But in Dallas, it's 90 days. If you do not give notice, or you do not have to give notice, if you sue the entity within 6 months. So the way I understand that is from the time of the incident, you must give them notice. Not from the time the incident or the issues brought about from the incident are over, but from the time the incident first happens.
Okay, we're talking about 1983 suit.
Correct. Title 42, 1983.
The city of Dallas, the state of Texas, has no power to abridge my rights in a 1942 U.S. Code 1983 suit. That's a federal statute. And
what I've been reading, Randy, is Google Title 42, and I'm seeing where case after case after case is being dismissed for not giving notice.
I really need to. Can you get me some case law on that?
I can send it to you. I don't have it handy, but it is really easy to find.
Yeah,
I'll just send you what I have.
Okay, just when you can, because I want to. There's got to be a context here that we're missing. I know if you're going to sue them in the state, and you have to give notice. You have to give them 60 days to make you whole. And like in a false imprisonment, you got 1 year to sue. 90 days is a very, very short time, especially for RICO.
Well, in let's see, Title 42, 1983, intentional tort is not 1 year; it's 2. Because 1 year, I can't think of all the verbiage they use, but 1 year does not give them does not give a person, which is the suing party, enough time to sue, and it defeats the Title 42's original purpose. Whereas they don't say this, but it's what I understand. Whereas the 1 year in the state, they're just doing that to keep people from suing them. But Dallas has a 90-day policy, and that policy for the tort letter or the tort notice, the tort acts of each state is set by the region. It's a local thing. Now, most people are doing 6 months, but Dallas has 90 days. That's incredible.
Yeah, but I don't care what Dallas's policy is.
Well, they're saying you can't sue them if you don't give them notice within 90 days. And it's 90 days of the incident.
If I'm suing in the Fed...
Hey, Randy, we're going to have to take a break for a sec. We'll be right back. This is Rule of Law Radio. Randy Kelton, Vet Pack. Please call us 512-646-1984. We got 30 more minutes. We'll be right back.
Everyone knows that walking is great exercise, but you might not know that the way you walk could predict how long you're going to live. I'm Dr. Catherine Albrecht, and I'll be back to tell you more about walking prognostication in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
New research shows how fast you walk could predict how long you're going to live. The Journal of the American Medical Association reports that older adults who walk 1 meter per second or faster live longer than expected. In case you're wondering, 1 meter per second is about 2.25 miles per hour. A senior's age, gender, and walking speed were as good at predicting life expectancy as more traditional statistical measures. Generally speaking, faster walkers live longer. Measuring walking speed is quick and inexpensive. It only takes a stopwatch, some space to walk, and a few minutes. Researchers say it could help doctors identify older patients who need special care. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
We are back. Rule of Law Radio, Randy Kelton, Vet Pack, and we are speaking with Ralph out of Texas. Randy, did you find any information?
I'm trying to research. I was doing some searching over the break, and I can't find anything on. Oh, here we go. 60-day pre-suit notice, Dallas-Fort Worth insurance lawyer. I can't find anything on RICO notice. Ralph, do you have any reference to that notice requirement?
I don't know much about RICO. I'm looking at causes. Let's see, cause of action elements.blogspot.com and coa.tx. That's one that I've used a couple of times. I'm reading a case right now. It's Alexander v. Walker. I don't know if that's the one I got it from.
Can you email that to me?
Yeah, I'll email it. I'm not real fast on email, so.
Yeah, I definitely want to look this up because something doesn't feel right here. I can't figure any way that either Dallas or the state of Texas could have anything to say about a federal RICO suit.
Well, now you said RICO suit. I'm just talking about Title 42, 1983, in that if you're suing the official.
I'm sorry, I'm mixing up RICO with 1983. Even 1983 is a federal tort claim, and the state has nothing to say about that. That would violate separation of powers. That would be a preemption of federal law, and the feds are not going to let the state preempt federal law.
That's what I'm reading on these cases. Okay, they're saying that what they're doing is they're applying state law in the federal courts with, not just blanket.
Okay, that they cannot do. That goes under the 2011 Venue and Removal Clarification Act. The federal court cannot adjudicate any state issue. Or maybe there's a distinction here where I can't see where they could be applying a state law to a federal issue. The Clarification Act said that they used to say that, I'm sorry, let me take a step or two back. There was a separation between the circuits. Some of the circuits said that if a issue with federal claims is removed to the federal court and the case has state and federal claims, the federal court can hear, under the doctrine of judicial economy, can hear both the state and the federal claims. Other circuits said, no, we can't hear state claims. That's an undue preemption of state law. 2011, the legislature stepped in to clear up the split between the circuits, and they went down on the side of preemption. Absolutely not. While a case with A state case with a federal issue can be removed to the federal court. The state issues must be severed and remanded. The federal court can't use state law. They can't rule on any state issue. They got to send that back to the state. So something doesn't fit here. There's something we're missing.
Can they use the statute of limitations?
No. The only limitations are federal limitations. The state they can't tell the feds anything. Now, the feds can tell the states some things. They can tell the states, you have to abide by our federal due process rights.
Yeah, I'm no expert at it. I've been reading, and the one I'm reading right now that I just mentioned, Alexander v. Walker, now that is a state case. But I'm sure I've read some federal cases, so I might be mixing them up. But I would tell Charles in Georgia to go Google Title 42, 1983, and notice and tort. Use those different words. I'm sure he knows how to do some word searches using the quotation marks for Title 42, 1983, et cetera, things like that. And I would err on the side of caution. And how much trouble is to send a tort letter?
I agree with that. But the reason that's a serious question for me is sometimes we don't realize that the issue has occurred until after 6 months. 6 months is a really short time.
Yes. And imagine the 90 days.
Yeah, 90 days is an impossibly short time.
Well, it should be challenged by somebody that's got lots of know-how and lots of money.
Yeah, if you can find any case law on that, I'd like to see it and read the case law. Because sometimes when we get people making claims, but when you read the whole case, then these issues make sense. I get a lot of stuff where guys read parts of cases and then jump to unfounded conclusions. The one that stands out is we have a mall, Northwest Mall, here in between Dallas and Fort Worth. And the mall was doing real well, and they wanted to buy property south of the mall to expand the mall, but there was a community there. And the mall got the city to take the property by eminent domain. The homeowner sued, went to the federal court, and the federal court threw it out, said, we don't have anything to say about this. And we had these guys crawling in, claiming that the feds were throwing us to the wolves, they weren't doing their job, and blah, blah, blah. Well, I read the case, and what the case said was eminent domain is a state issue, and we have no business intruding on the state sovereignty. If the people of the state of Texas feels that this is unjust, then they need to change state law. We have no power to intervene. And I read that, and I said, that's exactly what I want my Supreme to do. And the guys thought it was unjust because they didn't read the whole case. So we've got to be missing something. Ralph, if you can find anything, send it to me because I sure would like to address this. I would hate to have to give notice within 90 days. That would make a lot of suits impossible.
Do you have a tort letter on your website? I've never seen it, but I've heard you talk about it.
Well, I don't actually have a tort letter on my website. A tort letter, it's going to be real specific to each case. And when I create a tort letter, I actually write a lawsuit. A tort letter is a notice that you intend to sue if they don't make you whole. So I write the suit. This is my claim of harm in the form of a suit. I just change the header and the prayer to make me whole and be sued. That's so that when they get it and their lawyer reads it and I'm threatening to sue them, they're going to say, this guy's not kidding because he's already wrote the suit. So, but basically all the tort later is say, claiming how they've harmed you and then tell them, you harmed me in this amount, make me wholly be sued. So it's not much to it.
Okay. Well,
but it is a great tool. But, 90 days is just not enough time to research out a claim. And the last thing I want to do is give them fair warning.
Well, it doesn't make any sense to me, but what I'm reading, and of course, without me showing it to you, it's kind of hard for you to understand or, believe what I'm saying. But from what I'm understanding, it's a simple letter. It tells, it's under the Tort Claims Act of Texas, and it gives them a heads up that they're going to be noted, that they're going to be sued, or they may be sued. That way they can preserve evidence. Because if their officer goes out and shoots somebody and they don't know it, or they do anything, they arrest somebody illegally and the state doesn't know that they've done that illegally until 2 or 3 years later, whenever a federal lawsuit is filed, I should say 2 years later, you can't do it 3, then they're going to claim, well, we didn't have notice. That's what I'm reading. So that's what I'm understanding from what I'm reading. So they want notice as soon as possible. And this case in Austin, Ronaldo Munez, his attorney filed suit within 6 months. So I have not read that. I've only seen a little bit of it on the Internet. I haven't got on Pacer and read the complaint. But from what I understand is it matches up with everything I'm reading because he filed the suit within 6 months.
We're going to have to take a break. Let me put you on hold. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. We've got a few more minutes to call at 512-646-1984. We'll be right back. We are back. This is Rule of Law Radio, Randy Kelton, Vet Pack, and Ralph, you were speaking and I cut you off, so go right ahead. Continue. Ralph, are you there? Did we lose you?
Oh, hold on. My bad. There you go.
Come on, Randy, wake up. We still got 15 minutes left.
Hey, go ahead, Ralph. I've got you unmuted.
Well, if you don't have any other callers, I'd like to tell you a short story about what happened at the federal court a few weeks ago.
Okay, we've got 2 more callers, but there's no way we'll get time to get to them. Just go quickly, yeah.
Well, I went there and they said I had to have a state ID, a driver's license, or a passport to get in. I asked if I could see the law. They called the marshal to intimidate me. The marshal came out and says he'll find the law. And a half hour later, he comes out and there is no law. It's a local judge's ruling. But I can get in if they give me a rover. The rover escorts me around the courthouse. No recorders, no phones, and you have to have some kind of picture ID. Turns out it doesn't have to be state ID. It can be anything. Or you can get in with a rover if you have no ID. Now, I don't know if you're familiar with the Laney Walker case in Beaumont, Texas. Are you familiar with that?
Wait, say that again?
The Laney Walker, Judge Laney Walker case in Beaumont, Texas. Judge Walker was being sued in federal court for misappropriations of funds and mismanaging some cases. He pulled a gun on the process server when the process server came out to his house. So the process server went to the court to give the judge to serve the judge a summons, and he was arrested. And several attorneys and the judge filed complaints against the guy, saying that he was rude and obnoxious and loud and disturbing the court. So he was arrested. Well, he got out of court, and they gave him his possessions back. One of his possessions happened to be a pocket pen camera. So he, I hope I'm not messing this up. So the affidavits of these attorneys and the judge saying that he had, disrupted the court was proven wrong with his pen recorder, which showed he did not interrupt the court at all. So these attorneys that filed out this affidavit saying that this process server has interrupted court, that was the assistant district attorney and some of the leading attorneys in Beaumont area. Now, and also the bailiff. I don't think anything ever happened to him, and the judge retired.
Yeah, so I do remember something about that Judge Walker case.
Okay, they're not letting people in the federal court building with recorders unless the person is an attorney. Well, the attorneys are the only ones that we need to be recording, and they're the only ones that's going to lie, or they're going to be the only ones that's not going to tell the truth. I think something needs to be done about this. I don't know what.
Yes, somebody needs to file the suit. Now, it's a suit that needs to be there. There is case law in our favor. The Glick decision. Look up Glick. It's out of New Jersey. Boston. Police are beating up a guy on the street. A guy videotapes him with his cell phone. They arrest the guy. Guy turns out to be a lawyer, and he sued them. And the federal court, the issue was about a Boston ordinance that forbid citizens from videotaping police officers without the police officer's permission, and the court ruled that was unconstitutional. But they went on sui sponte to also address videotaping public officials. And they said that a citizen has a right to videotape his public officials in the performance of their duty. So we have case law that says that this court rule is in violation of Constitution, but nobody's challenged it. You want to challenge it?
That sounds good. Yeah, I'm going to challenge it. I'll be going there again pretty soon. And when the marshal was supposed to bring me the law, he didn't even bring the judge's ruling or motion. He just, or order, he just brought me a couple paragraphs out of it. So I don't know when it was signed. And I've got a feeling that it was signed or made into to an order after the Judge Laney Walker case. Well, we'll keep those people from showing we're liars. We'll just make a rule where they can't bring recorders into the courthouse.
And I've started to take that on a time or two. I was in Austin and going through the metal detector, and it was at JP's office, and I took out my cell phone and laid it down. They said, "You can't bring that in." I said, "Sure can." No, we have a rule. I said, "Well, you got a rule, I got a Constitution, and I got a court case that says you can wipe you behind with that rule." And they threw me out in the street.
Yeah.
But it just wasn't a fight that I had time to take on at the moment. If I got somebody that will take on the fight, I'll help them with research.
Yeah. Well, you got some good words, and sometimes that sets them on their heels, and that's what we've got to learn. We've got to learn the words that connect to their limited brain cells, I guess.
Yeah. Well, if you want to take it on, it's easy to get a claim. You just go down there and with a cell phone, or just put a pen in your pocket and tell the U.S. Marshal when he says something, "I'm old, I don't hear so good. Will you look and speak clearly into my pen, please?" And watch them get all excited and have them tell you can't bring a recorder in, and now you've been harmed. You've got the claim. I've got
Randy,
2 minutes.
We've got like about 5 minutes left. Did you want to bring on Robert before we close out the night?
Yeah, Ralph, send me an email. We're in touch. Randy at ruleoflawradio.com. You still there, Ralph? Okay, he must have bailed. Okay, yeah, he did. Hello, Robert. We've got about 5 minutes. What do you have for us?
Well, I had a couple of questions. Bennett that took my recording from me last week upon the judge's order and erased it. Do I have a case against him or the judge?
I would say that's a great case. What court were you in?
And I was in the Sacramento Court, Superior Court, Carroll Miller Justice Center in Department 87.
Then you might start with a criminal complaint against the judge. That's private property.
Okay.
Are you familiar with the Glick decision?
What is a Glick decision?
GL.
Look up Glick, G-L-I-C-K. It's a New Jersey case. And that's recent, and it's definitive. And it's federal.
Okay. And on the other one where they stopped me for no taillights and lied in court as to their probable cause, they said that they stopped me because that I didn't stop at a stop sign that wasn't there. And he lied that he did a U-turn and all this stuff. Since he didn't have any probable cause, okay, what should I write up the proposed statement? Was that
okay? If there was no stop sign where he said there was one, you charge him with aggravated perjury, tampering with the government document, and then you move to disqualify as a trespasser ab initio. Once he becomes a trespasser on the law, he becomes a trespasser from the beginning, and all his acts are, what was the term? Nullified something. All his acts are garbage. I forget the exact quote.
Poison tree.
Oh, all his acts are defeated. Garbage. So you look up trespass ab initio.
You write that down.
Once you give the judge notice of aggravated perjury, you do that in the form of a verified criminal affidavit. If the judge fails to act on your criminal notice and accepts the testimony, that's subordination of perjury. And that you should be able to charge in effect, because now he's stepping on federally protected rights of procedural due process. And subordination of perjury is 18 U.S. Code 4. I mean, it's not 18 U.S. Code 2936 or something. It's right up there in the front. It's actually the third one because U.S. Code 3 has been repealed. So the Congress seemed to think this was important enough right in the front. You should charge the judge with subordination.
Okay. So I should, on the not insufficiency of evidence, okay, there is no evidence that I was engaged in commerce, okay, or that the transportation code applied to me. I should be writing that into insufficiency.
Keep in mind, your only purpose in the trial court is to set the record for appeal. So don't get upset that they do things wrong. Be happy. You get to take them to the Court of Appeals and sting them with it.
I just got to get better at it before I hit the Court of Appeals.
Court of Appeals is a whole lot easier than the traffic court. The higher up you go, the more professional you are, the less BS you have to put up with.
Yeah,
that seems backwards, but they're a lot more sensitive to the politics and they're a lot more sensitive to the law. It gets better as you go up.
Okay.
Okay, we are out of time. Sorry we don't have more time, Robert. This is Randy Kelton, Vet Pack, Rule of Law Radio. We'll be back next Thursday and Friday with our regular shows. Make sure you listen to Eddie Craig on Mondays on Traffic. And Vet, you want to do our outro?
Well, yes, I absolutely do. I want to tell everybody, have a great Memorial Day weekend. You guys be safe out there, and we'll see you next week. Bye-bye and God bless. Good night. You took it. Dangerous.